Managers have various responsibilities to help their companies uphold and comply with sales law. They should know when goods are at the buyer's risk or the seller's risk. They should document all details of sales transactions. They should ensure accurate representation of their company's goods or services, and they should ensure goods or services sold are of reasonable quality for their stated purpose. With which aspects of sales is business law concerned? You probably wouldn't want to purchase an expensive item if you couldn't be sure that you'd receive it in one piece. Similarly, you'd want to know that if the sellers of a service didn't meet their obligations under an agreement, you'd have some sort of recourse. This is why contracts are necessary. They regulate and enforce agreements between individuals or companies. They create a sense of predictability and order, providing assurance and legal recourse to the contracting parties. A contract can be more technically defined as an agreement containing obligations that are enforceable by law. Individuals who enter into contracts agree to honour certain promises, which the law then recognises as binding. If any party breaks one of these promises, the other party has the right to seek assistance from a court. Contract laws are flexible in that they can regulate almost any type of agreement that two or more parties make. For example, types of contracts include sales, rentals, services, and employment contracts. Select each type of contract for more information about it. Sales contracts are developed when goods, services, or property are exchanged between a seller and a buyer at an agreed price. Rental contracts are created when one individual pays another for the use of an asset in the form of tangible property. This type of contract typically outlines rights and responsibilities of each party, as well as the price and duration of the rental. Service contracts regulate situations in which one party provides a service to another. This type of contract typically outlines conditions surrounding the service being provided, the responsibilities of the buyer and seller, and the price for the service. An employment contract is an agreement between an employer and an employee. It typically contains information about job-related responsibilities of the employee, details about how the employee will be remunerated, and conditions such as vacation and sick leave. Although contracts are considered binding by law, there are some forms of agreement that aren't binding. For example, a business issues an invitation to tender, but the lowest tender might not necessarily be accepted. That's because the acceptance of tenders may not create a legal obligation to award a contract. However, to be enforceable, contracts should not be contrary to the law. The law won't enforce contracts that are based on illegal or immoral conduct. In these cases, the contracts may be declared as void. For instance, Cecilia is a manager who's faced with the issue of a contract stating her company will sell fireworks to consumers. However, fireworks are banned in the area where she works due to safety concerns. As a result of being subject to the law of the land, a buyer would be unable to sue Cecilia's company, as the contract relates to the sale of an illegal item and as such wouldn't be enforceable through the courts. For contracts to be valid, they must have certain basic characteristics. They have to involve mutual assent and consideration. They must depend on the capacity of the parties involved to form an agreement, and the agreements defined in the contracts have to be legal. Select each characteristic to learn more about it. To be valid, a contract must involve mutual assent. In other words, all parties to the contract have to agree to it. Mutual assent is established when one party creates an offer and another party accepts it. For instance, after being interviewed, an individual is offered the job and agrees to the employment contract with the employer, thus creating mutual assent. Consideration is the exchange element in a contract. In other words, a promise in a contract will be enforceable only if something is given or promised in return. For example, if a car salesman sells a car, consideration is created when the buyer agrees to pay the sale price, the buyers exchanging money in return for the car. The capacity of parties refers to the ability of an individual to satisfy specific elements needed to enter a binding contract. Essentially, individuals must have the legal capacity to incur obligations of a contract. For instance, the capacity rule of a contract may state that any buyer should be over the age of 18. The capacity of parties could also refer to whether parties are of sound mind. For a contract to be enforceable by law, the purpose of the contract itself must be lawful. For example, a construction company is contracted to develop a building, and a clause in the contract with the building owner states that construction can only be done between midnight and 6 a.m. After the contract's signed, it's discovered that the town where the construction is to occur has a law that prohibits construction activity between 7 p.m. and 7 a.m. In this instance, the provisions of the contract regarding time can't be enforced because they're illegal. Under the law, remedies for breaching a contract can include damages, specific performance, or both. Damages refer to money that a court may award to one party as a result of the breach of a contract by the other party. Specific performance is the term used when a court instructs a party found responsible for breaching a contract to perform its part of the agreement. Identify the features of contracts. Managers have particular responsibilities in terms of helping their companies uphold contract law, ensuring the legality of any exchange, ensuring the capacity of the parties involved to enter into a contract, and documenting the details of all contracts. Match areas of business law with examples of a company's, and by extension a manager's, responsibilities. Each area may match to more than one example. 5 key areas of business law are those relating to sales, contracts, employment, intellectual property, and liability. Sales law governs the transfer of ownership from a buyer to a seller. Managers' responsibilities regarding sales law include knowing when goods are at the buyer's or seller's risk, documenting details of sales transactions, ensuring accurate representation of their company's goods and services, and ensuring goods and services are of reasonable quality. Contract law governs binding, legally enforceable agreements between parties. Managers' responsibilities in this area include ensuring the legality of exchanges, ensuring the capacity of the parties involved to enter into a contract, and documenting the details of contracts. Intellectual property is one of the 5 key areas of business law. It includes any creation of the mind, such as logos, scientific inventions, sound recordings, and literary or artistic works. Every year, companies spend millions of dollars on legal cases involving violations of intellectual property law, which protects the rights of individuals or companies to the intellectual property they own. Think about all the items in your company that you'd qualify as important intellectual property that you'd want to protect. Intellectual property law includes laws associated with patents, trademarks, copyrights and trade secrets. These are all aspects of intellectual property that organisations should safeguard. Select each aspect of intellectual property law for more information. Patents are granted to inventors and give them exclusive rights to make and sell their inventions for a specified period of time. They fall into three categories: utility, design, and plant patents. Trademarks are distinctive signs, words, images, or symbols that mark goods or services as having a particular source or standard of quality. If an individual or organisation has a registered trademark, it's not legal for any other party to use the same trademark. Copyrights are exclusive rights to produce or reproduce original work. Copyright protection covers literary works, pictorial, graphic and sculptural works, sound recordings, architectural works, and compilations. Trade secrets include any information held by a business that isn't commonly known and that may give the business a competitive advantage provided it isn't known to others. This could include formulas, processes, or designs, for example. Intellectual property laws may, for example, protect the rights to a particular manufacturing process, a design, or information about the composition of a product, such as the exact ingredients of a food item or the chemical makeup of a drug. Each country has its own regulations for how intellectual property rights are established and imposed, which has direct bearing on how business and licensing is done in those areas. Sometimes, the rights and protections granted in one country won't apply in another country. Managers should be familiar with the concept of fair use and its limitations. It refers to the limited use of intellectual property for certain purposes. Fair use can't be regarded as infringement and is therefore not illegal. An example is quoting part of a creative piece so that it can be commented upon or criticised. Similarly, you may want to comment on a book by writing a book review. To do this, you'd need to copy some of the book's text. This would be considered fair use. Consider a situation involving two companies. Company A designs and manufactures sports shoes for Company B. The sports shoes are very popular and generate a lot of revenue for both companies. A few months into their business relationship, Company B outsources Company A's sports shoe designs to another manufacturer, Company C. Unfortunately for Company A, this might not be fair, but it's legal because Company A never legally secured its intellectual property. It's crucial for organisations to protect their intellectual property, or they risk losing the competitive advantage that their information, ideas, and processes give them. For example, a pharmaceutical company might invest heavily in developing a new drug. But if there's no legal way to protect information about the chemical composition of the drug, any company might manufacture and sell it without having to invest in research and development. The original company would lose its competitive advantage, as well as its incentive for being the first to develop a groundbreaking drug. Because it's so important for companies to protect their intellectual property, most impose very strict policies governing how their intellectual property is managed. For example, in some industries, it's common to use non-disclosure clauses to prevent employees who leave a company from disclosing what they learned while working there. As well as protecting their own intellectual property, it's vital that companies avoid violating the intellectual property rights of others. This means it's also vital for managers to be familiar with intellectual property laws and to ensure they're upheld. As a manager, say you were aware that an employee was violating copyright laws but did nothing about it. For the company, the consequences could include a very costly lawsuit, heavy fines, a damaged reputation, and loss of business. For you as a manager, The result might be demotion or termination, as well as lasting damage to your professional and personal reputation. To help protect their company's intellectual property and avoid infringing on intellectual property laws, managers have certain responsibilities. Clarifying employee rights to materials they create at work, protecting their company's intellectual assets, and respecting the intellectual property rights of other parties. Select each responsibility of managers to learn more about it. Managers should always clarify what rights employees have to materials they create at work. This is because employees may invent or create materials while working within the scope of their employment, using a company's equipment, or at the expense of the company. The company may then be legally recognized as the owner of the invention or material, even if the employee never assigned the rights to it. To protect their company's intellectual property, managers have to ensure that the company's processes and design methods remain confidential. This involves ensuring that trade secrets are kept secret and imposing and upholding duties of non-disclosure on employees. It may also involve securing legal rights to the intellectual property. Managers are responsible for ensuring that the intellectual property rights of other parties are respected. This includes encouraging employees to respect patents, copyrights, trademarks, and trade secrets. In this way, managers protect their companies from being held liable for infringements of intellectual property laws. Why should managers be familiar with intellectual property laws? Another category of business law that managers need to be familiar with is employment law. The scope and focus of employment law has shifted dramatically over the last 100 or so years. Initially, it was generally accepted that power was held by employers only. Over time, the focus changed to incorporate fairness and better working conditions for employees. Recognition of employee rights has led to the development of anti-discrimination and anti-harassment legislation in most countries. Employment law is a broad area of law that governs the legal rights and responsibilities of employers and their employees. Among other things, it includes human resources, or HR, regulations and laws related to the safety of work environments, adequate compensation for employees, and employer-employee relationships. Select each area of employment law to learn more about it. HR regulations govern how companies can recruit and manage employees. These regulations deal with areas such as hiring, fair interviewing practices, termination of employment, and avoiding unfair discrimination in employment decisions. Various occupational health and safety standards are designed to ensure that employers provide their employees with safe working conditions. For example, they may be required to provide all employees with protective clothing or to take steps to minimize the risk of exposure to toxic chemicals. Laws also generally protect employees from harassment in the workplace. Employment laws regulate the minimum compensation that employers may offer employees. They also address issues such as compensation in cases of work-related injuries or deaths and unemployment pay. Employment law governs employer and employee relationships, protecting the rights of both parties. This has a positive effect on business. It's vital for managers to be familiar with employment laws so that they don't violate these laws, and in order to protect their companies from potential lawsuits. Potential, existing, or previous employees may file legal claims against a company for various types of offences, 3 common ones being discrimination, sexual harassment, and wrongful discharge. Legally, unfair discrimination in the workplace occurs when job candidates or employees are put at a disadvantage because of certain personal characteristics. In many countries, for example, discrimination refers to unfair treatment based on characteristics such as race, national origin, gender, religion, age, or disability. For instance, an employee may bring a lawsuit against a company because his application for a better position is denied based on the fact that he's over 40 years of age. An employee complains to the manager on several occasions that a co-worker has made several unwanted sexual advances to her, and the previous example demonstrates another common type of legal claim brought against companies by employees: sexual harassment. Though the employer did not personally harass the employee, this is an area in which courts have found employers liable for employees' actions because of the principle of vicarious liability. This is the principle that a superior may be held responsible for the actions of a subordinate. This principle may apply even if an employer is unaware of the actions that are taken by employees. The company can still be held liable for offences. So companies need to be aware of how the principle of vicarious liability may apply in sexual harassment cases. For another example, an employee brings a lawsuit against a company for sexual harassment after continuously receiving unwanted emails of a pornographic nature from a colleague. The employee complains to her manager, who chooses to ignore the complaints. Even if the employer was unaware of the emails and complaints, the company may still be held liable because of the principle of vicarious liability and the fact that the manager ignored the staff member's complaints. It's up to the employer to set and enforce clear policies prohibiting harassment behaviours and to respond to complaints. A third key type of legal claim is wrongful discharge. Suits of wrongful discharge are brought against companies by employees claiming that their employment was unfairly terminated. A termination may be seen as unfair because it's contrary to company policies and procedures, or because it violates an employee's legal rights. For instance, suppose an employee isn't performing at the standard the manager deems acceptable, and the manager fires the employee. The manager has not previously provided any feedback to the employee on job performance, nor has the manager given the employee the opportunity to address any performance issues. The employee subsequently sues the employer for wrongful dismissal. What are examples of some of the issues covered by employment law?